Joining us via Zoom is a constitutional lawyer and a rights activist, Samuel AKIN, joining us via Zoom. Mr. Samuel, thank you very much for making time. And we do appreciate you very much for joining us on the news update. First of all, your initial thoughts on this lawsuit and whether the grounds are enough to stop Ecowas from considering this military action.
Good afternoon, everyone, and it's my privilege to be here. I think first, let me say that it's an unfortunate situation we find ourselves in West Africa at this period. Niger, we are not there, but from what we are seeing in the news, it's under attack, and attack also extends to democracy, and that is what initiated the egalitarian mission for Africa and other concerned citizens of Nigeria to institute this action before the Ecowas court. The Ecowas court has jurisdiction to determine matters that borders on enforcement of fundamental rights of member states. And as we all know, Nigeria, Niger, West African countries are members of the Ecowas. And Ecowas has a treaty on peacekeeping that has been signed by these countries. We understand the need to restore democracy in Niger, but however, the law has to be followed, not just by instigating external aggression on Niger at the moment. We understand that the military has taken over, but Articles 26, Articles 25, Articles 27 of the ECOWAS articles on peacekeeping and resolution of conflict has provided for the guide and the steps to follow. So if this commission has failed to follow those guidelines, then we have a locus to go to the court, because as human rights organization, the ECOWAS has that jurisdiction, and we also have the locus to approach the court to see reason why this military aggression and intervention ought to be stopped. There should be peacekeeping first.
Right.
It is when this peacekeeping has failed that you can proceed.
Barrister, it's safe to say that the treaty does not foresee a situation where this could happen in the future, or perhaps did not decide to make it a part of the treaty when it was being signed back in '75. But there is also precedence for it, because also in the article, I think there's a part that also talks about it. Just before talking about non-aggression between member states, it also did talk about solidarity. And for most people, this is the whole point: solidarity to maintain democracy in Niger Republic. But away from that, let's bring back the situation, or perhaps reflect on the situation that happened back in late 2001 to early 2002, when the United States alongside Britain were considering invading Iraq. And I do remember the former UN Secretary General Kofi Annan and the entire United Nations basically saying that there is no grounds for war, this invasion should not go ahead, but it ended up happening. What are the chances that, regardless of what the court says, if ECOWAS sees the need for military action, that it does have the right to do so?
Like I said earlier, the ECOWAS treaty was signed by host countries. And by signing that, you have given an undertaking that to exercise your sovereignty, you have to follow the due process of the law. So the ECOWAS court has that jurisdiction to determine whether their action is right or not. So if the ECOWAS court has decided and given its decision, and then they go ahead and invade Niger, it will be a slap on the face to democracy, because the reason why they are saying they are going to Niger is to restore democracy. So if you are going to restore democracy by using military intervention, you are just, it's a disgrace. It's a disgrace. We cannot tell what their decision is, but the ECOWAS treaty provides, and the rules of the ECOWAS court provides that once an action has been filed before the court, parties must maintain status quo. So until the court decide, they ought not to take any further step in respect of this action.
Right. Obviously, this is unprecedented, because there was never a point in time when ECOWAS had to consider this particular situation. Now dealing with the courts, as well as
I agree with you.
In Niger Republic, is definitely going to be an eye-opener, looking at the treaty itself, those articles, and how the extraordinary summit that is scheduled to take place on Thursday is likely going to shed more light on it. But also, just shed light very briefly before we go on the provision that says that states must find a peaceful resolution to any conflict between states. And I reckon this does qualify as a conflict between Niger Republic, or at least the military leadership, and the rest of ECOWAS. How do you see this coming to light in the court?
I think that is even the ground for upon which we have gone to the court. Article 27 of the ECOWAS protocol relating to the mechanism for conflict prevention and management resolution, peacekeeping and security, that was signed in 1999 by both Nigeria, Niger, and some of these other countries. Has provided for how to resolve disputes between member states, to restore the conflict, is by approaching the territory and by having a meeting. The Security Council of the ECOWAS, we approach the host country, and then that will be, it is called mediation. The Article 27 provides for a mediation mechanism where they sit on the table and resolve the conflict. The essence of having ECOWAS is that all the countries are on the same page. So if you are invading another country,